If it had not been for that sock print, I would have found him innocent. Those are the words of Jake Bibb, one of the 12 jurors at my trial. He said these words on the day after the verdict against me. And that's what we're going to talk about today in this video. We're going to talk about the sock prints and also the shoe prints. The sock prints were probably the most important piece of evidence against me, and that's why I want to devote a whole video to the sock print evidence and also to the shoe print evidence. But before I do that, I want to say a few words about the comments in my last video. I want to thank all of you who said that I should let the past rest and focus on the future. I appreciate that, and I know you meant well when you said that. But the fact is, I did not get a pardon, and consequently I'm still being called a double murderer. The fact is, I did not kill Derek and Nancy Haysom, and I will not let people call me a double murderer without speaking back. I'm going to say my truth. It is the truth. I did not kill those people. And if people call me a double murderer, I got something to say about that. Like in this video about the sock prints and the shoe prints. As usual, everything is linked up in the video description. You can check all of this out for yourself. Don't trust me, read the reports, look at the pictures yourself. This terrible crime was discovered on April the 3rd, 1985. And one of the first things that the police saw when they entered the house was this sock print at the crime scene. It's called LR3, that's the name of it. You can look at it and you can see, first of all, that it's a sock print. It's not a footprint. Whoever left this print had a sock over their foot. That means there are no dermal ridges like there are with fingerprints. This is the equivalent of leaving a fingerprint with a glove on, okay? There's no identifying features. It's just a shape. And the other thing that we can see about this sock print is that it's completely smeared. I mean, check it out for yourself. Don't have to trust me. It's a mess. But the police photographed it because maybe it could somehow help them solve the crime. Next piece of evidence is an interrogation of Elizabeth Haysom 13 days after the police found the sock print. Here's trial transcript excerpt. You can see that on April the 16th, 13 days later, she told the assisting investigator at that time, Ricky Gardner, that she had size 8 feet. So the police knew this very early on, and that ends up being important later. So remember that. And then 2 months pass. We are now in the very beginning of June 1985, and something very strange happens. The Haysom family decides that they want to sell the house. And of course, the house is a crime scene. So normally what one would do is that one would hire a company that specializes on cleaning crime scenes. Unfortunately, there are companies like that who specialize on this sort of thing. It's a sad business. But it turns out Elizabeth talked her brothers into this idea that they should do it themselves. They themselves should clean their parents' blood from the house in order to sell the retirement home. That's a pretty strange idea. This is not something that I'm alleging. Elizabeth's insistence on cleaning the crime scene herself was discussed at length at her plea hearing in August 1987 and at her sentencing hearing in October 1987. Here, in this trial transcript excerpt, you can see what happened. A female witness, and I can tell you it's Annie Massey, her mother, Nancy Haysom's best friend. She has, in the meantime, passed away, so there's no, I'm not violating her privacy by saying this. As well as one of her brothers, Dr. Howard Haysom. And they observed Elizabeth as she took off her shoe and placed it over one of the sock prints at the crime scene to compare them. Pretty strange. Not necessarily evidence of guilt, but pretty strange. That was at the very beginning of June 1985. What's the next thing that happened? On the 7th of June 1985, there was a forensic report about the sock prints. And it was given by Rick Johnson from back then, Bureau of Forensic Sciences. It's now called the Department of Forensic Sciences. I've linked it up here. You can see that he looked at the sock prints and he said that they correspond to a size 6.5 to 7.5 woman's shoe and a size 5 to 6 man's shoe. Now, 6.5 to 7.5 woman's shoe, that's pretty close to Elizabeth's shoe size, size 8. And size 5 to 6 man's shoe, that's an extremely small man's shoe. That's really quite unusual. The report doesn't say this, but it suggests that this was probably left by a woman. So that's the state of the evidence regarding the sock prints in the summer of 1985. And then for 5 years, nothing happens with the sock prints, and that's the subject of this video. A lot of other stuff happened, of course. Elizabeth and I went on the run. We got arrested. I gave a confession, a false confession. Then she returned to Virginia, and in 1987, she was put on trial. And I fought extradition on death penalty charges. And then finally, in January 1990, 5 years later, I returned to Virginia. One of the very first things that the police did with me is that they took footprints of mine to compare to the sock print. And here is one of my footprints. You can see it here, 5 years later. First thing we notice is that this is a footprint. You can see it has dermal ridges. There's no sock over this foot. But they took this footprint and they compared it to the sock print LR3. That's like comparing apples and oranges. It's actually bogus. We can see that there's a problem here, but that's what they did. The very first thing that they noticed when they took this footprint is that I have a size 8.5 to 9 foot. That was a big problem for the prosecution because, remember, their forensic scientist, Rick Johnson, in the summer of 1985, said that sock print LR3 is man's size 5 to 6. And now you have a suspect here, Jens Soering, and he's size 8.5 to 9. That's a problem, if you're the prosecutor. In the normal course of events, that should have led the prosecution and the police to say, maybe something's not right, maybe we should investigate some more. But that's not what happened in this case. What they decided to do, they decided to send Rick Johnson into the desert. That's the forensic scientist who in the summer of 1985 said that this sock print is size 5 to 6. We never heard from Rick Johnson again. That man vanished. Instead, the prosecutor found himself somebody else, a man called Robert Hallet, who was willing to explain away the difference in length. And this, folks, this is something really important to focus on. When the forensic evidence indicates that the suspect, Jens Soering, did not leave a really important piece of evidence at the crime scene, instead of investigating more, they decided to just trade out their experts and find somebody to bend the facts to match their theory. That's wrong. That should not happen. Robert Hallet did exactly that. Robert Hallet took the photograph of LR3, the sock print, and then he took a clear photograph of my foot and laid it on top of the sock print. And you can see it here in this photograph. It's called an overlay. And in the next photograph, you can then see that he drew lots of little red arrows on that to point out alleged similarities. And then at the bottom, where it's clear that my foot is much longer than the sock print, he wrote in there, double impression. You can see it in the photo. Robert Hallet's theory was that there was a rolling of the heel, and that explains away the vast difference in length, 3/8 of an inch. Again, the difference between size 5 to 6 and 8.5 to 9. A double impression explains that away. My trial started on June the 1st, 1990. On the 4th of June, 1990, there was a hearing during the trial, but without the jury in the courtroom, where the judge ruled on Robert Hallet's status as a witness. Robert Hallet worked for the Forensic Science Department, and he was a tire expert. Nothing wrong with being a tire expert. I'm sure it's a good job. But that was his job. He was a tire expert. He was not an impressions expert. An impressions expert is somebody who testifies about fingerprints and footprints. That was not Robert Hallet's job. He was a tire expert, also a belt expert, but he was not an impressions expert. And for that reason, the judge said that he would not grant Robert Hallet expert witness status. That meant that Robert Hallet was not allowed to give his opinion to the jury. He could only show things to the jury, but he could not explain them or give his opinion about them. And that happened on the 4th of June, 1990. 9 days later, on June the 13th, Hallet then testified before the jury. Here's a photo. It's from the documentary Killing for Love. The producer gave me permission to use this photo. It's the only one I have of Hallet. And you can see him showing the jury his overlay. What did he tell the jury when he showed them this overlay? Here, excerpts from the trial transcript. He told them his theory of a double impression of the heel to explain away the difference in length. And he told them about his little red arrows on the photographs, which allegedly showed similarities. And that was actually the highlight of the prosecution case. This is what the prosecutor saved for last. And in his closing remarks to the jury, his closing statement on June 21st, 1990, he really hammered this home. Here are excerpts from, the man's name was Jim Updike. He was the prosecutor back then. And he told the jury that Robert Hallet had designated the sock print as his, meaning me, and that it matches and fits like a glove. So the prosecutor told the jury basically what Robert Hallet was not allowed to tell the jury, that sock print is Jens Soering's. They look alike, and you don't have to worry about the difference in length. And the jury found that very, very persuasive. Here is a newspaper interview, and in it you can find the remarks of Jake Bibb, one of the jurors in my case. He said in this interview that at the beginning of jury deliberations, it was actually 6-6. After a 3-week trial, the evidence really wasn't that strong. There were 6 for guilty and 6 for not guilty. Doesn't mean 6 for innocent. There's a difference between not guilty and innocent. Not guilty means reasonable doubt. So it was 6-6. And then, according to Jake Bibb, they took a closer look at that overlay with all the little red arrows on it. And very quickly, the jury came to the conclusion, hey, this guy's guilty, let's convict him. And the next day, Jake Bibb told the newspaper, if it had not been for the sock print, I would have found him innocent. That sock print cost me the next 29 to 30 years of my life, from my trial in 1990 until my release at the end of 2019. That remark by Jake Bibb in this newspaper interview finally woke up my attorney, Richard Neaton, who was a really bad attorney. I'll make another YouTube video about him some other time. He finally went into the files of Robert Hallet. Now, he could have done this before the trial. He should have done it before the trial, but he only did it after the trial, when it was too late. And what did he find in Robert Hallet's files? He found this. This is a footprint of Elizabeth Hasem's, which resembles sock print LR3 just as much as mine. No, it's actually closer, because this one here matches in length. Remember, Elizabeth had a foot that was size 8, and in 1985, Rick Johnson, the forensic examiner that disappeared, said that this sock print is size 6.5 to 7.5. Pretty close. Anyway, this footprint of Elizabeth is actually the very first one that she gave to the police, so there's no excuse for not recognizing it. Robert Hallet knew this. Robert Hallet knew that the first footprint that Elizabeth gave resembled LR3 very closely, but he did not show that to the jury. He kept his mouth shut about that, and my lawyer only found out when it was too late. 5 years later, 2 impressions experts, these are the real experts that are actually specialized on fingerprints and footprints, looked at all of this more closely. Remember, Robert Hallet was a tire and belt expert. Nothing wrong with that, he's just not an impressions expert. Russell Johnson and Fred Webb were impressions experts. This is Russell Johnson, different guy from Rick Johnson. Russell Johnson, you can see his affidavit here. He said that LR3 resembles in size only Elizabeth Hasem, not me. But that's not proof that she left that sock print. It just means that I'm excluded from having left that. She's a possibility, nothing more. And then he says that this sock print does not provide any evidence at all that I was at the crime scene because it's so smeared. And he says it should have never been used as evidence. And guys, you don't have to be an expert to recognize that that's true. You saw the sock prints earlier on. It's completely smeared. This should have never been used. The other expert, impressions expert, was a guy called Frederick Webb. And he was also an FBI special agent. And he gave this statement here, which you can read. He said that LR3, again, is very smeared and indistinct. And basically, anybody of that approximate size foot who has 5 toes, what he says, could have left LR3. It basically proves nothing. And he says that that overlay that Robert Hallet used is very misleading, or quite misleading, I think he says. And the arrows on the overlay are also misleading because they create an impression of precision that simply doesn't exist. Those little arrows point to things that don't mean anything. And both of these experts, and they are experts because they're specialized in this particular field, gave their opinions in 1985. And this is important to realize for those of you who do not come from Virginia. Virginia has something called the 21-day rule, which no other state in the United States has. It means that Any new evidence of innocence that is discovered more than 21 days after sentencing cannot be introduced, ever. Ever. So there's no way to get new evidence like this footprint of Elizabeth's and these affidavits from these two experts in court. You just can't ever do it. That's it. It's incredible, but true. I'm going to make a video about that, the 21-day rule, in future. But it basically means that the footprint of Elizabeth's and Russell Johnson's and Frederick Webb's affidavits could never be brought into court in an effort to show that the jury's verdict should be overturned and that I should get a new trial. 2 years after these two experts looked at the footprints, as part of my habeas corpus proceedings, the Assistant Attorney General, John McLeese, filed a brief, which lawyers do. This is 1997, and in this brief, he briefly talks about the footprints. And he says, here you can see it, that they could not be sized with precision, which of course is the truth. They're too damn smeared. John McLeese is right. They could not be sized with precision. They're smeared. But this is of course the exact opposite of what the prosecutor, James Updike, said at my trial. At my trial, Jim Updike said that Robert Hallet designated the sock print as mine, and it matches and fits like a glove. 7 years later, the Assistant Attorney General says, can't be sized with precision. Doesn't matter. How things change in 7 years, right? Another 12 years pass. We're now in 2009. And in 2009, a study is released called Invalid Forensic Science Testimony and Wrongful Convictions, put in the cover page here. This ends up being the gold standard study on something called junk science. You've probably heard of this by now. Most forensic sciences are in fact not scientific because they have no statistical basis. The only forensic sciences that are truly scientific are fingerprints and DNA. A lot of what goes for forensic science is actually junk science and has no significance, apart from the fact that lots of people get wrongfully convicted of crimes that they never committed, thanks to junk science. And there are now many states who are trying to do something about junk science. One of them is actually Texas. Texas has a junk science law, and of course Virginia does not have a junk science law. But this study here lays out all the problems with these fake forensic sciences. And it was written by Professor Brandon Garrett. Here he is. He was at the University of Virginia back then. Now he's at Duke University. He's the leading national expert on junk science. He's the guy. He's the man. And on page 72 of his study, he talks about, guess who? Robert Hallet. It's the case of Charles Fain in Idaho. Charles Fain was convicted in Idaho and spent 18 years on death row before he was declared innocent. He's completely not guilty. He's actually in the National Register of Exonerations, as we're going to see in a minute. But he spent 18 years under threat of the death penalty. Why? Because of Robert Hallet's lies. And on page 72 of the study, Professor Garrett lays it out. Professor Garrett provided my lawyers with excerpts from the trial transcript from Charles Fain's trial, where Robert Hallet testified against him, putting an innocent man on death row. Here are the pages from Charles Fain's trial. You can see what Robert Hallet did there. He did the exact same thing as at my trial. Look at it. He's talking about double impressions of the heel because in Charles Fain's trial, his foot was too long as well. So he comes out with his double impression theory again. And then you can see he also used overlays and he also used his damn little red arrows. And he sent Charles Fain to death row with these lies. And it took 18 years to get him off death row. And here he is in the National Registry of Exonerations, completely innocent. Of course, Idaho had the honor and the decency to declare Charles Fain innocent. Unfortunately, Virginia did not have that honor and decency in my case. But it's the same lies that put Charles Fain on death row that put me in prison for 33 years. Same lies and the same liar, Robert Hallet. And now we're going to talk about the shoe prints. People love overlooking the shoe prints because they prove that the theory of the prosecution cannot possibly be true. It's definitely not true. It doesn't mean it's proving my innocence. It just proves that the theory that the prosecution told the jury is 100% guaranteed not true. You don't need DNA, you don't need anything else. The shoe prints alone will prove this to you. Wait, give me a moment. We're going to get there. Here you see shoe print LR2. It's actually right next to the sock print LR3, but this is called shoe print LR2. And you can see it's got a wave pattern on the sole. And we know that it was not left by Derek Haysom because here's a picture of his shoes, and it was not left by Nancy Haysom, and here's a picture of her shoes. And what size is this shoe print? LR2. Deputy C.L. Baker's report, and here it is, tells us just 5 days after the discovery of the crime, he went to a bunch of different shoe stores and asked them. And they said that this shoe print LR2 is a woman's size 8 or a small boy's shoe. Remember, Elizabeth told the police just 8 days later that she had a size 8 shoe. Here's the transcript again. Doesn't mean that she left the shoe print. It just means that she has the right size foot, the right size shoe to have left LR2. And that is, of course, much too small to have been left by me. I wore 8.5 to 9. I'm not a small boy, and I have a perfectly regular size foot. So LR2, definitely 100% not my shoe print. It's just too small. And there's no double impression theory here to explain this away either. LR2 is just too small. That happened in 1985, and then we come to 2018, 33 years later. Somebody went through all the old crime scene photos, and guess what was found there? This. It's a second shoe print with a different sole, different pattern on it than LR2. It's difficult to see here. You have to digitally enhance it. Here it is digitally enhanced. You can see it's a big V pattern. And just to remind you, here's a digitally enhanced LR2. That's a wave pattern. Two different shoes. And here you see a picture as negatives, two entirely different shoes. One with a wave pattern and one with a big V pattern. What does this mean, folks? It means that two different people wearing two different kinds of sneakers walked around while those murders were being committed and left their shoe prints. And more than likely, a third person was walking around in socks, because who would take off their shoes in the middle of committing murder and then start walking around in socks? Doesn't make any sense. So what we've got based on the sock prints and the shoe prints is for sure two different sneakers and very, very likely a third person wearing socks walking around in the blood. And that's not what I told the police in my false confession, and it's not what the prosecutor told the jury. According to my false confession and according to what the prosecutor told the jury, I killed Derek and Nancy Haysom by myself. But here we have three different people walking around the crime scene in the blood. Doesn't fit. Cannot be true. It means that my confession is definitely false, definitely a lie, and it means that the prosecutor's theory of the case cannot be true. Cannot be true. Two different shoe prints plus sock prints. It's not evidence of innocence, folks. It just means that the most important piece of evidence against me, my confession, cannot be true, and that the prosecution's theory of the case cannot be true. I did not kill Derek and Nancy Haysom, and the sock print and the shoe print evidence create massive doubts about the prosecution's theory of the case. And on this alone, I should have been given a pardon, at least a conditional pardon, probably an absolute pardon. And it's just embarrassing for Virginia that they chickened out and didn't do it.